Uh-huh. I just don't get it. I do everything in my power to counsel over and over and over again. You are on probation in this court for DWI, and you've picked up a felony DWI. Serenity now. This is not going to go well. I'm telling you that now. So this is what we're going to do. I'm not going to let this go because I just don't have faith. And so this is what we're going to do. Mr. Ronnie, I'm going to put a scram ankle monitor on you today. You will be given a curfew of 7 p.m. to 7 a.m. On your other ankle, you're going to get a GPS monitor so I know where you are at all times. And then I'd like to send her for a TRAS right now. And we're going to see what the TRAS says. And then we'll go based on, I don't know how we're best going to go forward. They may say inpatient treatment. They may say outpatient. I don't know. But, and I don't even know if I'm going to we're going to keep her on.
I understand, Judge. We're just not talking about it. We're just kind of stuck with because the probation was only for a week and a half. There's no other violations other than the new charge. So we're kind of stuck with, we obviously can't come in and plead true to resolve it here. They can't really move forward on presenting a felony without the evidence. We don't have any blood back. So, I mean, I think that your proposal is the only thing you can do it. And
so let's send it for, let's do that now. And then she gets a scram today as well. And let's set it for a week.
Okay.
If you consume anything, I'm going to go bananas on your bond. Do you understand? I've set the bond at $2 million because it's over and over and over. I have no problem setting 5 to 6 zeros by the end of your bond. Do you understand? Come on. All right. We'll see you in a week.
This way. Judge, you said 1 week?
Yeah.
Okay. All right, Judge, the next is page 24. Moses, Walter.
I am so happy that you came. Good job coming today, Mr. Moses. I really, when you come to court, good things happen. And it just come back. Good things will happen when you do. All right? You're charged with criminal mischief. You're facing up to 6 months in jail. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay? Oh, please.
On December 29th, 2025 in Harris County, Texas, officer was dispatched to a criminal mischief call. Upon arrival, complainant pointed out defendant who was laying down on top of the hood of a car and was detained. Complainant stated she saw defendant running around the apartment complex, hitting and damaging other people's cars. All of a sudden, defendant ran towards her car, bumped into it, and started punching on her door. Defendant caused damage to the front driver's side door, costing about $300. Officer observed a video of the incident.
Okay. Do you mind, let's appoint him a lawyer. I'm going to have to take a seat in the jury box, and then I want them to converse, and let's see how we're going to go forward.
Okay.
Mr. Moses, I'm going to find that there's probable cause to go forward. You will not have contact with the complaining witness in this case. I'm going to appoint your lawyer today. Just go ahead, sign a reset with Victoria, then we'll have you take a seat in the jury box, okay? And then we'll talk here momentarily.
All right, Judge, right to vote.
No.
Page 24, law.
I wanted to talk to you a little first, and then we'll craft the conditions based on that. Good morning, sir.
Good morning, sir.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
I think he's going to Walter P.
Oh, you.
Oh, excuse me, I didn't say. This one.
Oh, Come on in.
Once.
Are your ears burning?
Sir?
Are your ears burning?
Yes.
Wonderful. Okay, are you ready? Ready?
Sorry.
Let's roll.
On January 12th, 2025, in Harris County, Texas, on patrol, officer on patrol at 11:10 p.m. observed a motor vehicle hit his brakes multiple times and speed up and slow down. Officer then conducted a traffic stop and observed the defendant to have glossy eyes and slight slurred speech, and the defendant advised that he had a drink. Officer observed an open container, cup holder with an empty container of alcohol. Officer asked what was in the tumbler that the defendant was holding. The defendant gave the tumbler to the officer, which was cold to the touch, 3/4 cold, and had a strong odor of alcoholic beverage emitting from it. An inventory search later found another container under the driver's seat and an empty flask. SFSTs were conducted, 6 out of 6 HGN, 6 out of 8 walk and turn, 3 out of 4 one-leg stand. The EIC was read, defendant consented to a blood sample.
I would venture a guess that it's damn elementary that you're not to have alcohol in the car while you are driving, and is a minimum of 6 days in jail if they prove it at trial. As a condition of your bond, you're ordered not to, well, I'm going to find that there's probable cause to go forward with your case, and I'm now placing a restriction on you, sir. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If I find that you drive a vehicle that doesn't have one, I will revoke your bond, put you in jail. No more PR bonds for you. Do you understand, sir? I'm sending notice to DPS in Austin so that every police officer in the state knows if they pull you over and that car doesn't have an interlock, they're going to take you to jail. Do you understand?
Yes.
You will be randomly tested for drugs and alcohol as well. If I find that you're using, likewise, you will go to jail. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with him. If he tells me he cannot get a hold of you, I'm going to revoke the bond. Do you understand?
Yes, sir.
All right, I'll have you sign a reset with Victoria. We'll have you get with Roxana.
Where
And
do
then,
we talk to get the interlock right?
all right, good luck.
Right, Ms. Fleischer. All right, Judge, page 27, Palomino, come on up. All right, no, Mr. Monster.
Sir, you were charged with racing on a highway. You're facing up to 6 months in jail and or $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On January 11th, 2026, Harris County, Texas, officer observed several vehicles traveling at a high rate of speed on US 290. Officer observed defendant's vehicle position itself next to another vehicle. Both vehicles slowed to approximately 50 miles per hour before rapidly accelerating while side by side in an attempt to outdistance each other. Officer estimated both vehicle speeds to reach approximately 100 miles per hour, as the officer was traveling 92 miles per hour and was not getting distance on them. Traffic stop was conducted and officer made contact with the defendant, who was the driver, as well as a passenger.
Okay. License?
Eligible, you're not.
Sir, I'm going to find that there's probable cause to go forward to the case as a condition of your bond. I'm ordering you not to drive in this manner again. If you do, the first thing I will do is I will put you in jail, and then I'm going to take your ability to drive away from you. Living in a city as big as Houston without the ability to drive blows. Do you understand? Not only that, the legislature's made it very easy for DAs across the state to seize and take cars from individuals who participate in these types of actions. And I've seen it where they've taken cars, $50,000, $75,000 cars permanently. Do you understand? We are going to reset your case to give you time to hire a lawyer. I'll have you go, Victoria, sign a reset. We'll have you take your seat in the jury box. I'm going to get your bond conditions. Once you sign them, at that point, you'll be free to go. No racing, street takeover, donuts, etc.
Yes,
Please.
Go ahead. All right, Judge, page 29, South.
Good morning. Sir, you were charged with theft. You're facing up to 6 months in jail and or $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On January 11, 2026, in Harris County, Texas, officer was dispatched to an academy in reference to a theft. The manager reported that defendant had stolen a speaker valued at $250, causing all points of sale without rendering and fled the store on foot. Officer located defendant matching the description given by the manager.
Right out of the gate, this is already spiraling. Being on probation for a DWI and picking up a felony DWI, that's not just a slip-up, that's a pattern. And judges don't ignore patterns like this. Question for you. At what point does the system stop giving chances and start locking things down?
Defendant gave commands, or officer gave commands to defendant to stop, but defendant ran away. Officer pursued defendant on foot for approximately 50 feet until defendant stopped and complied. Officer observed a speaker partially exposed in defendant's left side jacket pocket. Defendant stated that somebody had given it to him earlier. The academy manager confirmed that defendant was the one who committed the theft.
Sir, I'm going to find that there's probable cause to go forward to the case as a condition of your bond. You're ordered not to go to any academy,
Yes.
not to go to any academy whatsoever for any reason. If you do, I will revoke your bond, put you in jail. If you pick up a new case, likewise, same thing will happen. Do you understand? Do you have the ability to hire a lawyer? We will give you time. I will have you go sign a reset. We'll have you take a seat in the jury box and get your bond conditions. Once you sign them, at that point, you'll be free to go.
All right, Judge, top of 35, Torres, come on up.
Conditions.
Please, yeah, no going to any academy. Sir, you are charged with driving while your license is suspended. You're facing up to 6 months in jail and or $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On January 12, 2026, in Harris County, Texas, officer conducted a traffic stop on a vehicle for expired registration. Officer made contact with the driver. While conducting a driver's license and persons check, officer discovered that defendant's driving status was not eligible. Defendant stated he knew his driver's license was not valid.
What was the stop for again?
It was a stop for an expired registration.
Got it. Mr. Torres, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to drive any vehicle whatsoever for any reason. And you will be signing an affidavit with me today promising me that you're not going to drive. If I find that you do, I'm telling you now, I will go bananas on your bond. Do you understand me? You cannot justify getting into a car and driving for any reason. I don't care what you have to do in this life. Work, food, school, church, nothing. Do you understand?
It looks like council barely filed the attorney report.
On this gentleman?
Yeah, about 20 minutes ago.
Okay. So let's just wait for Council get here to do the reset. Let's go ahead and have him sign conditions now.
So the no driving affidavit?
Yeah, that, and then can you file also no driving, please?
Yes, Your Honor.
All right, come on up. We'll have you sign this, and then we'll have you wait for your lawyer to get here.
All right, Judge, the last one is on page 37. Worthy, come on up.
Good morning. You were charged with assault, bodily injury. You're facing up to a year in jail and or $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On March 9, 2021, officer was dispatched in reference to assault. The complainant stated that the defendant was dropping off her kids so that she could enjoy her son's birthday today. The complainant stated the defendant was causing disturbance by arguing and name-calling her husband. The complainant stated after the defendant left the residence along with her husband. The complainant stated her daughter later notified her that the defendant, her son, and her boyfriend confronted her husband outside. The complainant stated she went outside to use the situation from escalating by telling her husband to come inside the residence. The complainant stated while talking to her husband, the defendant approached her, confronted her face to face. The complainant stated while she was confronted, the defendant pushed her to the ground, causing her to feel pain and discomfort.
So it was a push to the ground.
Yes, Your Honor.
Okay. I'm going to find that there's probable cause to go forward with the case. As a condition of your bond, you're ordered not to have any contact with this person, not to be in possession of any weapons. You understand? Do you have the ability to hire a lawyer? Okay, I can have you fill out an application. We'll take a look to see whether you qualify. I need to know everything about you, whether you work, how much money you have coming in, and I'll take a look to see whether you qualify. Deputy Williams will give you an application. You can go hire a lawyer if you don't qualify. Yeah. So, well, let's see. I mean, I need you to fill out an application. We'll take a look. And Deputy Williams will give you one. Do not leave until you sign the bond conditions, though, please. Okay. So no contact, no. Hey. Ready? Hey.
I have Mr. Gary Spencer on today for a bond violation report.
Come on up. Tell me what's up.
I was received a report from Free Crawl about the late unapproved exits and entries. And looking at the GPS, it's hitting a gas station that's right behind the apartment complex. They're, I think, on 4 separate days. One, they were able to call and he let them know he's in his backyard, and they got the unapproved entry after that. But it looks like all of them are about 20 minutes, 30 minutes, and it's just hitting.
One is at 11, past 11:15, you know?
Yes, sir.
And Aaron, as much as I appreciate you, it's over, and it's over, and it's over, and we're now on our 4th bond violation. You are not getting the picture, sir. Over and over and over. I have bent over backwards not to put you in jail. But this is your 4th, and you will now go to jail. I'm revoking your bond. I'll set it at 10,004, because it's the 4th one, and then just let me know. He'll auto-populate until tomorrow's docket, so, yeah, please, thanks, Aaron. Hey, hi,
I didn't want to interrupt.
that's okay, what's up?
I have Mr. Alejandro Castillo on the docket today.
Yes.
He's in jail?
No, this is on bond,
Okay,
and we had entered into a 1-year PTI for him to pay for 17 amount. He's well on his way, Judge. He's has a balance of 6,900. He has been making payments. He has even made payments when he's like locked out. So he's on his way, and he finds he has family members that help him every now and then, but he's
okay, give me 1 second, give me a. How much is he paying?
He's paid 3,795.
Right, and two's left?
Yes, 2,997.
So when's the next payment? And how much does he have left?
On the 15th. And restitution, he has 24,92 left. And so I would have.
And how much is left in time as far as?
That's 16.
Okay, so I would say he at least do, I mean, 500, 600 a month, right? So let's do another status, probably like 2 months prior to termination, and let's see how far he is, okay?
Sounds good.
Yes, okay.
He's a hardworking kid.
Great.
Good job taking all the advice and everything.
As soon as it's done, then we'll, right, yeah, okay, thanks.
Judge, how long ago we set?
Yeah, do like 3.5 months. Roxana, on the one that picked up with the DWI 3rd, we protested for illegal. Hey, what's the last name? How's it going?
But, you know.
He did the TRAS?
Yeah, he was already sent.
Oh, they're sending him now.
Oh, yeah, he came in this morning to record.
Great. So we'll give you like 2 weeks to finish everything up. Yeah? Okay, for sure. So if they're off docket, what I need you to do is let her know.
And there it is, full control mode. Scram monitor, GPS tracking, curfew. This isn't just supervision, it's a legal lockdown. The court is basically saying, we don't trust you outside a controlled environment. Legally, this is about risk management, but emotionally, you can feel the judge's patience running out.
We'll put them on docket and make sure your clients are here so we can address it then. I don't grant it off docket because then they get here, we never knew about it.
Right, what about the case one warrant status?
Okay, then I'll grant it. If it's in warrant status, then yeah. No. Just have them go to the queue.
Okay.
Yeah, I'll sign it. If it's in warrant status, for sure.
Okay.
Is she here?
Yes, Judge, I think the box.
Come up, ma'am. Is that her? Hold on. No, that's her. In the brown, right there. Miss McDougal? McDougal? Yeah. Hey, can I borrow one of you guys? Sean, I think it's yours. Can I give you a case number?
Yes.
2600091.
26009.
Yeah,
Borrow design.
it's hers. Oops, sorry. Is it M or N? The letter where you guys switch off.
It's like the first half of the M, so it's.
Oh, for the love of Pete. I mean, really?
It's so.
Come on. Okay. Ma'am, you're charged with criminal trespass of a habitation or shelter. That makes it a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On January 5th, 2026, officers dispatched an alarm call at 5503 Pebble Springs Drive in Harris County, Texas. Complainant stated he could see defendant on a live feed. Complainant stated he could see defendant in the garage, then stated he observed defendant in the backyard. Complainant was not on the scene. Officers made contact with defendant who stated she lived at the residence. Complainant arrived on scene, confirmed that it was his residence and that defendant did not have permission to be there.
So no relation or anything?
No, it's not evident from the DIMS, Your Honor, that there's a relation.
Any prior criminal history?
Yes, Your Honor, she has an extensive criminal history.
Extensive criminal history.
She has 3 prior ADIs, a prior criminal trespass, 2 prior criminal mischiefs, an assault of a police officer, a terror secret.
Any Berghabs or anything like that?
Sorry, Your Honor?
Berghabs or anything like
No
that?
Berghabs.
Ma'am, I'm going to find that there's probable cause to go forward with the case. I'm now going to place a GPS monitor on your ankle so I know where you are at all times. Your case is in warrant status now because you failed to make court. I will reinstate your bond today. You get 1. If you ever fail to appear again, I will revoke it, and this time I will put you in. Do you understand me? Do you have the ability to hire a lawyer? I can have you fill out an application. I'll take a look to see whether you qualify. I need to know everything about you. Ma'am, do not go back to this house. Do you understand? Do not have any weapons. If I find that you violate these conditions, if you pick up a new case, it's not going to go well between us. Do you understand? I'm going to protect my community at all costs. I don't care who you are, how old you are, anything. Do you understand?
Yes, sir.
All right, come on.
Yeah.
Bond and sales.
Your Honor, there's a pre-trial permission.
No, I'm gonna have her monitored, so you don't need to. She'll be. So a total of 1, 2, 3, 4 cases are being dismissed
Yes, Your Honor.
in exchange for your plea on the 5th case. How was jail?
Yes, jail.
You know, we have it for a reason. You know what happens when you endanger our community. It's there to not only protect, but to also teach. And have you learned that actions have consequences, and you cannot you cannot continue to do what you do and expect good things to happen. Do you understand?
Yes, sir.
And the thing is with your history now and the way it looks, anytime you come in contact with the laws, it's probably not going to end well. You understand?
Yes, sir.
The agreement that you have worked out is 1 year in jail, and we are giving you credit for the 83 days that you have done. You need to understand that this will reflect as a conviction on your record. It will be there for the rest of your life. Even after you die, it's still there. There is also an affirmative finding of family violence. What that means is that if you ever pick up you can never pick up another gun, ammunition. If you ever pick up another one of these cases again, from now on, you are looking at a 3rd-degree felony. If you thought this was bad, start reading what it's like in prison. I was reading this article the other day, and they were detailing the life of a person in prison now who is doing life for some capital case. And they were a bunch of groups like the ACLU and all these other groups concerned because of this mental deterioration of this person who's sitting in prison now, where he literally sits in a cage, a 9 by 12 cage. And I promise you, he sits there 23 hours a day, 7 days a week. The only time they let him out is in a cage so he can get just a little bit of exercise and shower, maybe a couple times a week. And while he's in that cage, he has about 10 guards that surround him the entire time. He is literally sitting there like a freaking caged animal. And his mind is now deteriorating so bad that he's not himself anymore. This is what happens when you go to prison. It's not a pretty sight. Do you understand?
Okay.
So please, it's not a joke. And with this, you are giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you accept this plea of guilty, like I said, it will go on your record. It will be there forever. There's also the affirmative finding of family violence. So if you pick up another assault like this, and it doesn't have to be a drag down where you beat the hell out of someone, grab someone's arm enough and squeeze it to where it hurts, you'll be facing up to 10 years in prison next time. You understand?
Yeah.
How do you plead to the offense, guilty or not guilty?
Guilty.
I'm going to find you guilty. I will sentence you to this agreement. Good luck.
Did you catch that? 5 to 6 zeros on your bond. That's not casual talk. That's a warning shot. Bonds this high are designed to keep you in jail, not give you a way out. So ask yourself, does this sound like a second chance or the last one?
Hi.
Hi, good morning.
Now, before we
Okay. What's your cause number?
2009-804.
You know, I see what you're
Okay.
Not here today, but, it looks like in order they have to analyze the device. You know, our good time on January, I know it's just probably still in town, it just says he doesn't have a bunch to get it out. So I think they gave it up, I want to, one of our list report, but I want to start close to this. So, I think,
I was just gonna make sure. And then I'll get.
So let's do this. Let's put him on docket for tomorrow. Because he's got to be here. So I can talk to him and admonish him. You know, he was supposed to get it that 18 days ago. Here we are on the 20th. Had we not reached out to him, he would have never done anything. You know what I mean?
Well, he knows what I do on the night, so, and he checked me when I was wrong Friday.
That's okay. So let's put him on for tomorrow and then let him know he's got to be here and then we'll fix it.
Okay, understood. Thank you.
Yes, ma'am. Hey,
More good.
what's up? Last name?
J-A-H-A.
Okay.
And, spoke with the state and we're still using the MGT from the post slip. It was marked complete, still the reaching out to the admin to see where it is, but it's not discovered.
So let's do a 10-day discovery setting. You've got 10 days to get it. If you don't get it, then you know how it goes, huh? I mean, really. We're nearly at 180 days and we're supposed to have it. So, all right, 10 days. Yep. Hey, ready?
Yes.
Hey, what's up, man? What's the last name?
It's Kristen Cannon, it's off Docket. 2577 347. We're set February 4th. I just need about 3 weeks. I think it depends on where she is. She's about to have some surgery, so we need some time to get through the
File a motion for continuance. I'll grant it. Why?
I'm just asking for 3 weeks, it's off Docket.
Oh, are you set for trial?
No,
Oh, I thought you were set for trial.
no, it's just,
Oh, no. I'm sorry. I thought you were set for trial.
I did not clarify that, sorry.
I thought you said we're set.
No,
I assumed that.
we are set February 4th, but it is kind of at the end of the road, but it's not a problem.
Okay. All right.
Good? Okay.
I thought you were set for trial. In that case, I would want a motion, but
That I get.
okay, sure.
Thank you.
Absolutely.
Oh, hey, this is his.
Hey,
Judge, how are you?
Muncie, I'm granting it for you.
Thank you, I appreciate it.
Get with Ramona, okay?
Also, Judge, as far as the case goes, I got an email from Caitlin this
I
morning
can't hear
saying
you.
that
It's too
they're...
loud in here, man.
Okay,
Just get with Ramona.
okay, sounds good, Judge.
Okay, man.
All right, thanks, bye. Oh, Judge, you want her to, she just waits there, right? That you'll give her a copy.
I can't hear you, Brad.
Okay, no problem. I'll
Okay.
email her.
Have fun, man.
All right, thanks.
Hey,
Sister Ramirez.
okay. Good morning, Mr. Ramirez. Mr. Ramirez, you were placed on probation for failure to stop and give information. You're facing up to 6 months in jail and or a $2,000 fine. It looks like it has not worked out, so now you want to accept this agreement. What you need to understand is that I'm now going to revoke your probation, going to sentence you to 60 days in jail. I will give you credit for the 21 days that you've done. But you need to understand that this will now reflect as a conviction on your record and it will be there for the rest of your life. From now on, you're facing a minimum of 30 days in jail. Do you understand? You are giving up the right to a trial. I'm sorry. Is it true or untrue that you violated your probation? I'm going to find that it's true. I'm now going to revoke your probation, sentence you to 60 days in jail. I will give you credit for the 21 days that you've done. Good luck to you, sir. Thank you. Hi.
Good morning, man.
Come on up. Who's the last name?
Collins,
Got it.
W-A-S.
I got it. So it's 97 days old. You just want to reset?
Actually, Judge, I filed a motion to withdraw this case. Is it a non-payment?
No. Is the person here?
Yes, Mr.
Come up, sir.
What was me good?
It's not a good morning. When your lawyer's upset with you, that's not a good morning. What are you doing with yourself these days?
I'm taking care of my daughter, full-time mother, find a job, once you get, she's trying to get back to Florida.
And when is the last time you've had a full-time job?
Before I got arrested in jail. I mean, in court, so that's on my food.
Oh. Councilman Rita?
I need you to fill out an application for me, Mr. Bounds Carter. I'm going to set you 2 weeks from today. You best do everything in your power, as many applications as you can, because you don't get to sit at home and play Xbox all day while the people of Harris County are paying for you. It's time for you to get a J-O-B, full time, and you will be tested upon your return. Do you understand? 2 weeks. Deputy Williams, can you give an application? All right, I'll grant your motion. Okay, yes, thanks for coming early.
Good morning.
Hey, come on up. What's the last name? Okay, what's up?
So Judge, Mr. Hunter was released at bail on Friday. He had nothing to do with his probation. So I understand that he checked in this morning. I was actually able to get a hold of him on the phone, even though from,
He's not here.
he has left, Judge.
It's been like this for the last 2 years, where he does what he wants to do. Just,
Judge, I will just state for the record, I have been informed that his mother had a medical issue that required him to leave court early. He felt that he was headed to the hospital now.
I mean, this is probably his 8th failure to appear, give or take. Yeah. So it's at 15,003 now, so let's do, I guess 25,004. Maybe that'll get it. Yeah. This is his 8th failure to appear. I can't tell you how many bond violations, and I've literally extended him courtesy after courtesy after courtesy. We filed a motion to revoke. It doesn't even, sorry, because at that point now we'll just continue to be enabling his behavior, and I can't just continue to do that. So, I guess we'll just see what happens. Okay, thank you. Hey,
You ready?
yeah, what's the last name?
This is around $2 ready for a case number?
Yeah, hold on.
It's a Thursday.
Oh, you want to do it today?
No, we're trying to, get it off application from you because the PPI contract's not ready yet and it's set for Thursday.
Where are you at in the process?
It's not bad, it's a once you.
No. Where are you at in the process, though?
Oh, we're supposed to have the contract ready by Thursday.
Okay.
But I reached out to Henry, he wants a letter from his employer to get a portable device, but my client can't get a letter from his employer because they know that the charge
Okay,
is,
so, but why would they want to?
because we're asking for a portable device now.
Oh, okay. So I'm assuming it's old though, right?
It's a June.
How long do you want?
Just a week.
Okay, fine. But if it's not done by then,
Yeah,
that's it.
We're trying to get it. I'm trying to get it.
All right. Okay,
Thank you.
you got it. Hey, hi, Ellen, how are you?
Just
You have someone on the docket today?
I do, Judge.
What's last name?
Thomas, the Don Thomas, he's in custody.
We have 130 on the docket today, so it's like this thing is about as thick as the Bible. So he picked up a felony.
Yes, Judge, that's fine.
Let's see.
Council Lisa?
So the felony set for 212?
Can we just do the following week, Judge? Of course. The 16th.
Yeah, absolutely.
Thank you.
Yeah. Hi.
Good morning, sir.
Hi, good morning. Okay, what's the word?
So we had all the documents in, we just waiting to confirm everything.
They still haven't done it.
He still got an email today saying that they need to take our information, but he has all the information. So he sent it to him, it was supposed to put out the school.
Is it on Docket today or no?
It was on my docket, but it didn't.
So can we
it
keep-
on my mind.
Yeah, I didn't see it either. Ask her what. Ask her and then let's set it maybe just a couple days.
Yeah, not tomorrow, Judge.
Okay.
Oh, tomorrow.
You want to just wait till tomorrow and see if they ready to do it?
Yeah.
Yeah?
Yeah.
Okay. Yeah.
They take a little while.
Well, hopefully that.
Now this is a completely different tone. Same courtroom, but notice the shift. Encouragement instead of pressure. Showing up to court actually matters. Legally, it signals compliance. Psychologically, it buys you credibility. And in court, credibility is currency.
That's enough, you know.
Absolutely.
Can you send them an email saying, hey, look, everything's done? I mean,
Yeah, I had an update as of like 5 minutes ago for that, and that's what we were talking about.
okay,
So,
yeah.
All
All
right.
right. Thanks, buddy.
Judge, can I ask you a question on conditions?
On who? We did it earlier today?
Yes.
Okay.
I just wanted to make sure that we're following on, there's no contact.
Yeah, no contact, no weapons. Yeah, that's right. Hey,
Hey, Judge.
hey, what's left Fleischer?
Yes, sir.
Jail or bond?
No, I'm on Judge, he's present. There's a BDR. So it looks like it was a failure to report for drug and alcohol testing. He's willing to take a test today, Judge. For some reason, he said that he didn't get those communications. He's
So-
available to do it.
Great, we'll send them now.
Okay,
We'll go from there.
all right, thank you.
We may have to roll it, this is kind of late. I don't know how long it's going to take, so may have to roll it till tomorrow.
Yes, sir.
Okay.
That's fine.
Okay, thanks. Hi, Mr. D.
May I approach, Your Honor?
Yeah, what's going on?
Yes, sir, Your Honor. We were here last week on Ms. Erin Hernandez. At that time, she was taken into custody. Subsequent to that, she has made bond, and we need to get some bond conditions on.
Okay. I think we already did conditions last time.
Did we,
Yeah, it should just like, no going back to the trespass, no contact, no weapons with the complaining witness and the mischief,
yes, sir.
and then no drugs, no alcohol, random testing. Yeah, so just if you want to let Roxanne know,
Yes, sir.
just the standard condition.
Thank you, Your Honor.
Sure. Thanks, Mr. D. Hi, please.
Good morning, how are you?
Hey, happy Monday. Oh, two. Right, who's the first? Last name.
The person I was told that, he would like
So, have you spoken to him?
Yes.
I just want to make sure that he shows up because he has a ton of non-appearances.
Right.
Right. I want to make sure he's also, if he's under any kind of psychiatric care, that he takes his medication as well. The only thing I'm interested in is him just coming to court, stay out of trouble, that's it, you know? So, you know, the conditions are just no drugs, no alcohol, take your medications prescribed, stay out of trouble. I mean, and then I don't know if you also want to do like an evaluation as well. It's up to you, but what, you know, my biggest thing is we have so many non-appearances. And I'm so happy that he's here. This is maybe like the second time ever that he's appeared here. So this is fantastic. So positive reinforcement, you know?
I'll talk to mom to monitor the channel. So,
Okay. Yeah,
Just
just
the information is for
just be patient, take care. We want him to show up so that it's not. Just look at the priors. It's mind-numbing how many FTAs we have. So, but now this is great that he's actually showing up. So we want to keep fostering that. So just take care and please, you know, take your time. But that's it. Yeah, what is it?
On 5/7. 5/30.
Okay.
We talked about this guy. He was on probation for assault, violent injury. It's in an accident and he has like severe traumatic brain injury, severe cognitive delay. So we put him on probation September 25th. On September 30th, he picked up a DWI and evading arrest. That's what's caused all of his delays. They just filed the charges on 14th. So I'm not sure what you think is doing on the motion, but I don't think he's gonna be able to do it. That's how it's not fair. That's what the probation officer is telling me. She asked him his name, 30 seconds later, he was like, where am I? He might be on.
Man, hey, was that because of a car accident or what? Man, tell you what, they can just mangle the hell out of it, you know? Sheesh. I guess let's do this. Let's do a court admonishment so we can appoint him a lawyer. I mean, there's a warrant out for his arrest anyways. So
They just filed it on the 14th. But we don't have a motion or anything.
when did it?
It
So,
happened on September 30th, and I guess it was a 2-week offense in this.
no, but that was after he went on probation.
5 days after. So we put him on probation September 25th, he gets in an accident September 30th.
Yeah, he's got a felony warrant and he's got a misdemeanor warrant. So let's do this. Let him know. Let's.
So I
guess so. You know, yeah. We just don't know when we're gonna.
What do you want to say?
10,000 too. Yeah.
Thank you.
Okay.
Hey, how you doing today?
What's up, man?
My father, previously we wanted to put around the defendant would like to come out and speak to the court because of,
Mr. Kim?
Hi, Judge.
Good morning.
turn risk, man.
Does he want a bond?
You know, this isn't one where he's entitled to one, but they have until today to pick up. It is a pre-signed waiver, which is why
Today's the 30th day?
today's the 14th day.
Oh, well then that's, okay.
Right.
I mean, usually it's 30. I'm happy to explain it to him.
But,
Hey, Edge, do you mind, who is it?
this is for you.
Michigan, huh? You don't get many Michiganders.
Yeah. I just assumed the right man to come. I mean, they come here and, all the way to No, he been in since December 5th, so that's another reason why he's.
I'll let him know. I mean, remember, because when there's a pre-signed waiver, it's 30 days, not the customary 14, right?
But I'll also explain the hiccup.
Well, yeah, so there's an additional hiccup?
There is a hiccup.
He had a pending case here.
Oh, well, hold on. He just had a case, he just pled to a case.
It's still from that date. It's still today. That's not a swampy issue.
Okay.
So I think he was arrested on December 5th with the spiritual injury in his arm.
He pled on that day.
No, he was arrested in December.
Oh, December. I thought you said January. Okay.
And he thought that the time was going and then when.
No. I'll change. How are you?
I'm all right, what's the subject?
Pretty good. So, you know, when you sign for probation, when you sign for parole, you always have to read the fine print because there's so many little details, there's so many little nuances that you have to get to know when you get on probation or parole, because it may come back and later on and really bite you in the boo-boo, right? So here, you signed for parole conditions on 22, Mr. Turner. Let me show you this. One of the things that you signed here is the states where I may be found. I also agree that I will not contest any effort to return me to the state of Michigan, and I agree to reimburse the state of Michigan for the cost of my extradition if I leave without permission. In effect, you say, if you ever take off, you have already waived. If I wanted to give you a bond, I cannot, because you have already waived by virtue of signing this agreement. We normally give, without these waivers, we give 14 days, and if the jurisdiction doesn't come pick you up, then we release you. When we have pre-signed waivers, though, it's 30 days, so it's not the usual 14 days.
All right, so what about, okay, last Tuesday, 13, they came. I sat down there for 20 hours. Down at ATW, they down there for 20 hours, and they didn't even take me.
So I don't know, again, I received this information just before the approach. Obviously, I'll get to the bottom of it, but possibly related to that is I was informed by Michigan, because they still want him, they very much still want him, they didn't know what was going on until a couple hours ago, is that the transport company, when they had him, he has a wearable defibrillator, basically a life vest suit, and while they do accommodate for medical, they weren't able to accommodate for that at the time of transport.
You have a defibrillator?
Yes. So they do a flight and not ground transport because they have the extra precautions when they go up in the air. That's why they couldn't accommodate.
That was at 24.
It's damn elementary. That line says everything. This isn't a gray area case. Open alcohol, failed sobriety tests, admission of drinking. It's stacking evidence. From a legal standpoint, this is the kind of case prosecutors love. But here's the twist. Do strict conditions actually prevent repeat behavior, or just delay it?
That was in 24. They came, and I was in Montgomery County, I was in 24. I'm talking about this the 13th last week. That they came.
The same reason why they don't agree is because that's why
There's certain precautions that they want to take so that they ensure that your health is not compromised if they take a flight. I know that there are special issues when you have a defibrillator and you go up in the air. I think it may be a little bit more dangerous. I'm not too terribly sure.
Safety, because I believe so. That's what I'm thinking of the email. I'm still getting to the bottom of it because again, Michigan also doesn't know. They're talking about third party transport company. They escalate your supervisor. I'm learning all this in real time, so I don't have the answer right now.
There was a human flying. I was in the back of the transportation van.
And when they probably learned that you had a defibrillator, they said, you know what, we better take extra precaution because we're going to fly now. It's probably not a good idea to get him in flying back to Michigan. It's probably a better idea to drive him back. So
they was driving. I was in the transportation van.
I don't know. Regardless, though, they're still within the allotted time that they have to come pick you up.
How much time left now?
You became eligible for pickup when you took care of that case that you had on the 5th, right? So it would be 30 days from that day.
Okay. So if they don't come get me by February 4th,
No.
31 days.
Well, the court date would be then, because we still need to process the day after, so you get released the day before, so you don't pick up, but yes.
So we'll do the reset for what day?
February 5th, unless you want it sooner. I mean, that's why I don't think the reason for a lot of you.
Okay. You're right. You're right. So hopefully they come by then. If not, then that's it.
The judge said last time, said they'll come by the trial within the 14 days, they were going to release it. And I knew they wasn't coming, it's the second time they came and didn't come and didn't take me. Now this dry sitting there. And I asked them, they didn't want me to come and pay this, ain't no, but this is my fine. Well, I owe us the $1,400 for my restitution.
So it's probably a good idea.
And they told me they didn't even want me. So I went back to Michigan when my brother died.
Okay.
I went back.
It doesn't matter. It's not in our hands at this point. We have to do by statute what we have to do. We just don't bend the rules for, so you have to understand, sir.
Right. That's exactly what y'all doing. Because the paper I signed, the waiver, it said 14 days.
That is the normal waiver, but you have already a pre-signed one, so that special rules kick in. So regardless, if this is your second time, right, you have to understand that every time Michigan issues a warrant for one reason or the other, it's going to take some time out, so this is going to happen.
Set for the 5th. And
Yeah.
come to you about the 5th. Didn't work. Now it's set for 2 more weeks.
So I got 30 seconds ago, so again, in real time, they're saying, and I don't have this in writing from our sheriff's office, but they stated that he's not medically cleared to be transported, which is a different problem.
See?
Because if he's not medically cleared statutorily, that holds, I don't know, which is my point of telling
And then they just went
you.
to, I was gonna be sitting here.
As it pertains to the other extradition, there was one out of December, but that was an out of county and not out of state. It could be that he had one in Montgomery County or another contiguous county, I don't know, but I do show an out of county extradition that was refused.
So what's it gonna take to clear him medically then?
Sorry?
What's it gonna take to clear him medically?
That's what I'm trying to get to the bottom of right now, because it has to be our sheriff's office.
So why don't we do this? Why don't we do this? Can we roll it till tomorrow to try to get some more information?
We'll get answers from all.
So we're gonna try to help you out. Don't fret.
Okay, we
We-
have something to the prosecutor, right? I don't have.
No, don't talk to the prosecutor.
Okay.
You're not allowed.
I'm sorry.
But I'm telling you, we're gonna try to get the bottom to see what it takes to get you medically cleared so that you can get ready for transport. We're not gonna let you just sit here and rot. Doesn't work like that. We're gonna try to do everything in our power to be as efficient as possible. But hopefully tomorrow is enough time for him to gather the information. I don't know. We'll come back tomorrow and hopefully he'll have an answer as to why, what it'll take to get transport with the defibrillator. I don't know. So we'll see you tomorrow and hopefully we'll have an answer for you then.
I'll roll. Thank you, Josh.
Yeah, thanks. Okay, thanks, guys.
Oh, sorry, I'm still putting in the pre-sent waiver, the remand order.
I've signed it.
Okay.
Oh, wait. No,
Oh, sorry.
I signed it. Yeah, for sure. Hey, you wanna go through the list?
Yeah.
Oh.
Yeah, they're not again.
Judge, Taco Base 2, apparently there's a.
5,00001. Oh, hey. What's up? Hey.
Nice to see you. Happy New Year.
You? Happy New Year. What's that?
No, no, sir. Bill Fabulous. It's still for Docket, later on. Trial? In this situation where they're evaluating the case,
It's only 67 days old.
Yeah, apparently the spouse, said what the non-prosecution.
Okay, I don't wanna know.
Well, we're just waiting to see.
Okay,
Just set the trial, but I mean.
It's 67 days, is it 67 days old?
From the matter.
Yeah, it's super early.
Well, here's what happened on the part approaching. And I'm even opposed to this, but apparently they have an immigration Senate meeting in San Antonio coming up in February, first of February. The invitation for her, but she needs to bring her spouse to be interviewed as part of that process. So we've got a thing with fair.
There's no travel restriction.
Yeah, but they're supposed to not be here, so she was the plain witness, the spouse.
But that's a
She's
different
also
question.
submitted all of the non-prosecution data, but still evaluating the case on that. And then so unfortunately.
Take a seat, sir.
That's kind of like what pushed us a little bit here, Your Honor, because they both are being asked to be at this immigration hearing. He does have the invitation on his phone, which they were supposed to email it to everybody. That's from office though, because
Oh, give me 1 second. Let me look this up. I don't know. I mean, the facts are pretty bad, man. My concern is the complaining witness, not anything else regarding him. And here, he's got prior criminal history, allegedly forced her head into a wall, sustaining a large laceration, and just, I don't know, man. Just, what do you guys think?
Doesn't have any objection to the modification of the calendar.
So we have been in contact with complaining witness speaker and lining that up on this.
Well, Joe, I can tell you right now, I'm not going to do anything until they talk to the complaining witness, and they've not been able to talk to her, right? Because I don't know what her side is, and
Our back got in contact with her and she stated to the back that she doesn't want to pursue charges, but we ourselves have not been able to speak to her.
Yeah, I'd like you guys to, so I know, and then that way you can get the rip done. Why don't we set it for like a week to get the rip done, and then we'll go from there. But until I know, and then because I have to give them, set it for a week, and then we'll come back and then we can argue at that point. Ask all the questions that pertain, safety and all that, and we'll go from there. Yeah, okay.
Appreciate it.
Sure.
On page 3, Bedford, how much do you want to go with?
10,004. And then top of page 4, is that another one?
Yes, Judge.
So, is it that he picked up a new case? Is that what it was?
I didn't read it, Judge.
So, okay, 5,001.
Vito?
No.
This one's Judge. Page 10, sexual arraignment, fellowship here. Both cases.
And boom, this is where the hammer drops. Fourth bond violation. Not the first, not the second, the fourth. At this point, the court isn't debating anymore, it's enforcing. This is the moment where leniency officially expires. Hard question, should repeat violations eliminate second chances entirely?
Let me get there. Okay, what is it?
It's 259-2855.
Oh, give me 1 second. Let me take it. Oy.
So I'm the felony prosecutor on this new DB case upstairs, but I was informed.
You're the felony prosecutor?
Yes, Judge. I was informed by my judge in Court 487 that I needed to ask Court 5 for permission about the Sentinel records because the basis of the VPO 212 is based off of the fact that he's being monitored in Court 5.
Okay.
So I just wanted to check in and see if we could get those Sentinel.
Let's do this. He's in jail now.
That's correct. He just did the mow up upstairs in 487.
Can I put him on docket for tomorrow?
I think he is actually ready.
Great, because we need to also address, if he picked up a felony BPO, we need to also address conditions here, because he's got a BPO and an assault
Yes,
here.
Judge.
So let's do this. Can we talk tomorrow?
Definitely.
So can I reach out to my staff, because I don't know how that what kind of position that puts me in,
Sure, definitely. And I do think that we have a motion, I filed it, at least at the felony court, but I was supposed to just kind of check in down here, because technically he's being monitored in Part 5.
Yeah, yeah, okay,
Okay, perfect.
Yeah.
I think I'm back.
thanks. Is it because you guys are having a hearing on the MOAP, or?
Yes, Judge, I did file a motion for an 11C in felony, and so we were hoping to have those records instead of having to bring my complaining witness to testify as to the violations.
Got it, okay. Mr. D.
Yes, sir, Your Honor.
Hey.
Thank you, sir. Your Honor, I am here on Mr. Chauncey Joseph. Back in April of 2025, fine was based on deferred adjudication probation for unlawful carrying of weapons. Subsequent to that, I've received notifications from the probation officer that client violated with some technical violations, inclusive of failure to do his community service, report, tested positive for marijuana on one occasion, failing to attend the educational program, thinking for a change.
Yeah, we had quite a number of issues with him while he was on bond too.
Failure to report, and get verification of school enrollment.
Well, what's reasonable, It's his fourth case in a year.
I think he just picked up assault in the high school.
Shut the front door. What?
I checked with the chief, Judge, and we looked over that, and the chief couldn't find anything in state or out of state relative to
I tried
that.
to run, I didn't see it in Harris County. I tried to run it through, NCIC to see, I didn't see anything pop up.
Where are you seeing this?
The probation officer told me. He obtained a law violation for assault by family member on 116 in the accident.
Let's do this. Can we roll it to tomorrow? And will you look into it to see?
Wait a minute, I'm sorry, Judge, I do see an arrest picture,
Okay.
but I don't see a charge.
Okay.
An arrest
I see a
picture.
mugshot in 116. Maybe it's out of county, there just takes a while to update, like, that's another possibility, Judge. And it could be, let me see if there's any booking patterns.
I don't want to do anything until we know for sure. So maybe we could set it for a couple days to give them time to look.
Every day, Judge.
Yeah,
We'll go
but
Wednesday,
whatever, you know,
it's only Thursday. Okay, fair enough.
yeah, whatever you want, Mr. Moore.
Issued. Warrant issue on this one. So yeah, I don't see one, Judge, but yeah, maybe it could even be out of county and it's just taking a while.
I'm Brad, so take your time. Maybe an investigator can see if something, you know, set up a couple days and then we'll
Yeah,
come
but
back.
I do see mugshot in 116, so I don't know if that was, he did have a warrant out here. He got picked up as part of that, but.
Okay, you should know something about Thursday.
Yeah.
Okay,
Fair enough, Judge.
yeah.
Okay.
Judge Taco 22, a step 4 arraignment failed to appear and has a felony over the warrant.
What page was that?
Taco 26, I will give it a name. You want this to be commission?
5001.
Below that one, Martinez, it's a petition for non-disclosure.
I was gonna say 1,000, I'm sorry, 14,129 days old.
Here,
Jeez.
I don't know, later.
Who's next?
Page 26, Odom. Step 4 arraignment failed to appear.
2501.
Top of page 37, Williams. Step 4 arraignment failed to appear.
2501.
Nothing approach. On Victor Gonzalez, the Marley Network, still states are connected. Clear for appearance next, first, second.
Oh, yeah. Okay, coming up, guys. All right, so Ms. Alvarez, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. And Mr. Gonzalez, you're charged with theft. You are facing up to a year in jail as well. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Dealer's choice.
November 26th, there, the same thing, drop. So,
Oh, yeah, okay.
November 26th, 2025, officer spoke to complaining witness who advised that she was in a physical altercation with defendant 1 and defendant 2 outside of her apartment at 4201 Fairmont Parkway in Harrisburg, Texas. Complainant advised she received phone calls from defendant Alvarez, and she then came outside where she was struck in the face multiple times by defendant Gonzalez and defendant Alvarez, and then fell to the ground and hit her head on a metal post near her apartment door. Officer observed injury to the head and blood, and that defendant Gonzalez took her phone and keychain before leaving the scene.
Okay. Is there any kind of relation whatsoever that you know about, perhaps?
Not that I know about, Your Honor. The DIM said there was a argument over, I think it was like a T-shirt or something like that. But
Over a T-shirt. I am finding probable cause on.
Sorry, it's
It's okay.
but does it make reference to the minor that was I just didn't know if there was any more there that good reason or the bus that might put it up there.
Judge, I was redirect within the agreements here. The complainant stated that when she walked outside, she saw defendant one's sister, hereafter referred to as defendant two, and both of the defendant's fathers, hereafter referred to as defendant three. The complainant stated defendant one told her to run it. And this is, I know this is in many else raised, but, defendant one told her to, quote, run it, and began to strike the complainant multiple times with closed fist. To the complainant, she heard defendant three tell defendant number two to jump in, and that's when defendant two began to strike the complainant multiple times, along with defendant number one. Complainant added that in the course of defendant number one, defendant two's jumping on her, she fell to the ground and hit her head on a metal post near the apartment door. Complainant stated that after the altercation, she observed defendant three grab her phone and keychain prior to defendants fleeing the scene. It should be noted that the defendants attempted to get to defendants number one and two for their account. The incident had told that both defendants refused to speak to the law enforcement officers. Officers simply contacted them, number three via the phone, not addressing negative results. As far as, where are you seeing that?
Joe, are you saying that there's a justification or something?
I believe you haven't identified them with defendant three.
We didn't have anything charged under defendant three, so I think one was probably taken on judge, which is why there's three defendants, from what I can see here. What I can say is, Your Honor, the complainant, from what we have, is a 16-year-old acquaintance. It doesn't really say what other relations there are. I'm trying to look at. I have to say that she was that. I mean, I'm just trying to see.
Well, guys, I am going to find that there's probable cause to go forward with your case. As a condition of your bond, you're not to go within 200 feet of where this complaining witness lives, works, breathes at all. You are not to have contact with this person whatsoever. You're not to be in possession of any weapons. I'm telling you now, if I find that you're a danger to my community, I only have one place for you. Do you understand? This is not a revolving door, and if I have to put you in jail, you will not get another PR bond. That means no new cases. Don't violate these conditions. I don't care what the cause is. Do you understand? You both have a lawyer. It is your responsibility to talk with him, and he can advise you on how going forward with all issues related to these cases. That's it. So what we're going to do now is I'm going to have you both sign a reset. I'll have you both take a seat while we get your bond conditions. Once you sign them, at that point, you'll be free to go. Okay, so will you do me a favor also? Will you reach out to the complaining witness to let them know the condition that they're not to go within 200 feet so that they know if something should happen to notify, and then we'll take appropriate action.
Yes, sir.
Okay, all right. Please.
This way.
So no contact, no weapon.